Hey, I wanted to talk to you a little bit about workers' comp settlements and the structures that those kinds of settlements go into. So typically in workers' comp, we have one of two different ways that we can settle cases. In a perfect world, you would want to take some of the features of one of the settlement structures and some of the features of the other settlement structure and kind of merge it together and make something that works for you. But we can't do that. In workers' comp, the way that our settlements work is we have to either pick option number one or option number two. We can't kind of mix and match and make it our own, unfortunately. And each one of these settlement options has both good and bad things that go with it. There's no perfect way that we can settle a case because, like I said, we can't make it our own. We have to kind of pick one of these pre-designated structures for the settlement. So the first settlement is settlement number one is what's considered to be a stipulation and request for an award. So what you'll hear me talk about that as is a stip. So the benefit of the stip is that it's going to provide a lifetime of medical care for you. So that sounds great on paper, right? You know, like a lifetime of medical care. It's on a coupon. It doesn't expire. It lasts for the rest of your life. So theoretically, you could be 90 years old tooting around a nursing home and still be able to get treatment for your workers' comp injury through the workers' comp system. Now, so that's the benefit of that kind of settlement. The negative of that kind of settlement is it's going to be a settlement for less money because the insurance carrier is still continuing to pay those medical bills for the rest of your life, so they're not really going to be inclined to pay you as much. How those settlements work is the doctor at the end of the case will give you a percentage of disability, and that could be a scale from 0% all the way up to 100% disability. And so everybody kind of falls somewhere on that particular scale. And the percentage of disability is equal to a dollar figure from a chart. And it's paid at a rate of $290 per week. That's the state maximum. Nobody makes anything more than that. People can make less than that. So for example, our clients who are part-time workers or we're making minimum wage, sometimes they may be on less than $290 per week, but nobody can be more than that. And so essentially what happens is the doctor assigns you a percentage of disability. You get paid that percentage of disability from that chart, and then future medical care is held open. And so one of the negatives is that you do have to go to the doctors usually within the insurance company's medical provider network, and so you have to go to the doctors they choose or that are pre-chosen. We'll help you find the better doctors in that network, but you still have to go to the doctors that are in their network. You can't just pick and choose your own doctors. And you only get the treatment that they approve for you. So essentially it's the equivalent of what is going on throughout the life of the workers' comp case. You just get to continue with that process moving forward. It doesn't give you access to more or to less medical treatment. It's just saying, hey, we're going to give you the opportunity of requesting it, and then we'll decide what we approve or we deny. So that's sometimes a little frustrating for people, but again, there's pros and cons for each one of these settlement options. For our clients who are still working for their employers, it's a different it's a different kind of settlement, or this is actually the only kind of settlement that we can do. It has nothing to do with your employer or you specifically or anything like that. It's pretty standard up and down the entire state of California, no matter which insurance company that we're dealing with. As long as someone is still working for their employer, almost exclusively, we're going to do this kind of settlement. The second kind of settlement option that we have is what's called a compromise and release, or you'll hear me refer to that as a CNR. So the CNR is a more traditional type of settlement. This is where they basically say, you know what, here's some money, please be done. We're done with you, you're done with us. Everybody is kind of breaking ties, and it's a full, complete, final settlement to the workers' comp claim. So that also has some pros and some cons. And so the pro of this kind of settlement is emotionally it feels like more of a settlement. You're going to get a lump sum amount of money. You're not going to get paid every 2 weeks like the first kind of settlement. It's a lump sum amount of money, so it's going to feel like more of a settlement for you. It's going to completely close out your medical case because they are no longer paying for the doctors in your future. They're paying you. So it's going to give you the ability to go to the doctor on an as-needed basis or with whatever doctor you want to, and you pay that doctor from your settlement proceeds. So let's say, for example, and I'm just using this for an example, if you are having a flare-up and you want to go see a physical therapist, you just call the physical therapist office and say, hey, I'm going to pay you guys cash. Can I come in? And they're going to let you come in for treatment. So it gives you a whole lot more control over the types of doctors that you're going to, because you're no longer within the confines of the workers' comp system, and you're no longer waiting for that insurance company to pay that doctor. You're going to pay, for whoever it is, cash from your settlement. So that definitely has some pros because it's more of a control factor. But there's negatives too. Number one, it's a final settlement to the claim. I cannot go back and undo that decision. So I can't go back and say, oh, oopsies, we ran out of money, or that turned out to not be enough. And so it's a full final settlement of the claim. Like I said at the beginning, is in a perfect world, you kind of would pick the best features of both of those settlements and combine them into one. But that's really not how that works. The compromise and release settlement is something that we can do for people who are no longer working for their employer. We can also discuss the open medical, which is the settlement option number one for people who are not working for their employer anymore. They just people who aren't working there tend to have a little bit more flexibility in terms of settlement. Now, again, that's not something that's directed by your particular employer. What happens is it's from the insurance company. So the insurance company says, hey, wait, if I'm cashing out this guy's back claim, the last thing that I want is for, 6 months from now, this person to come back in and say, oh, oops, my back hurts again. And then they're on the hook to pay for another back claim. So they only want to do that cash out, we're all done with each other type of settlement when there's no risk of you having another injury that they have to pay for. Is it fair? Probably not, but that's how the process works. So what happens if we can't reach a settlement, if the parties can't agree? So let's say, for example, we're talking about that compromise and release, that lump sum type of settlement. And we're here and the insurance company is here and nobody is moving. We're just too far apart and we can't make it happen. By default, we end up with settlement option number one, which is open medical care. And we can either agree to that open medical care or we can take it to trial and the judge will award open medical care and the percentage of disability. And so, unfortunately, I cannot take a case to trial and say, Judge, my client wants this number with a complete buyout, but they only want to pay this number, make them pay that higher number. The judge actually doesn't have the authority to do that. And sometimes that serves to protect my clients because the insurance company really, really wants them to take this number that's down here. And it's protecting my client from getting forced into a settlement that they don't want. Sometimes it stinks, and sometimes it's a situation where my client, I really, really, really want them to be able to have this settlement, and I want to be able to force that insurance company to pay the higher number, and I can't force it, and the judge can't force it. So the judge cannot force either party to pay or accept a compromise and release or a lump sum type of settlement. The judge can only say, well, hey, here's your percentage of disability, and here's your open future medical care. So I created this video just to kind of go through the general settlement options for you, so you can kind of have that kind of stirring around in your head, so you understand, like, okay, my case is going to fit into one of these categories and things like that. So when you consult with me or you consult with the other attorney at the office, Jacob, he and I are going to go through it with you, and we're going to talk about how your case fits into these a couple of options. Now, this is the how cases work for most people. Now there are some exceptions. One of those exceptions is the if someone is age 62 and a half or older, or they have applied for Social Security disability. Now that's different than EDD. So EDD is the state program that's run from the state of California. Social Security disability is the program that's ran through the federal government, and it's kind of similar to regular Social Security, except for there's a disability component to it. So if someone has applied for Social Security disability, regardless of their age, they could be, and my client could be age 22 and apply for Social Security disability, or age 65 and apply for Social Security disability. It doesn't matter. At any age, if someone applies for Social Security disability, or they're age 62 and a half or older, there's some extra hoops that we have to jump through for those particular clients. We'll talk about that definitely in more detail. Also, kind of want to talk about some potential deductions that could be happening from either one of these settlements. So settlement option number 1 or settlement option number 2, there are going to be deductions that come from the settlement. The first deduction is attorney's fees. Attorney's fees for our office are 15% of whatever your final settlement is. So just making up numbers here, but if your final settlement is $10,000, attorney's fees are 15%, $1,500. You would take home the remainder, which is 85%, $8,500, assuming there's no further deductions. There could be additional deductions if there's some type of overpayment that happens. And overpayments happen in cases, it doesn't mean that my client has done something wrong to generate that overpayment, but sometimes it happens where medical reports aren't received in time, or things like that, and it's not anybody's fault that it happens, but there could be a potential overpayment that we need to discuss. And then any sort of payments that are labeled as permanent disability payments or permanent disability advances. Those are called advances for a reason. It's because it's a prepayment to your settlement. So if you've received any checks, usually our clue that you're receiving those permanent disability checks is, number 1, we get a notice in the mail that says you're now receiving permanent disability checks. But also, if maybe you didn't get that notice, if your payments are an even dollar figure, if they are $580 for that every 2-week period, those are almost always considered to be permanent disability checks, and those are going to be deducted from future settlements as well. So we'll definitely talk more about these settlement options, these deductions, and things like that as they pertain to your specific case. But this is just kind of a general overview so you can kind of understand the big picture, and we'll talk individually about how your particular case falls into each one of these structures. Thanks so much, and have a great day.